Okay, well, what I'll do is I'll start now. I'm conscious everybody's blocked out their diaries to be part of this webinar. The Scottish Tourism Alliance, we're absolutely delighted to be bringing this webinar to you with our most newest members, SPS Advisory, and we're joined today by Phil Grady and Roger Franklin, who'll speak to you a little later. Well, very shortly, should I say? I suppose to put some context as to why we're really pleased to be doing this. We're well aware, of course, of the challenges that the industry is facing right now. Many businesses still very fragile in terms of their financial position and precarious. However, what we're also very mindful of is that a number of businesses out there had hoped to make claims for business interruption during COVID. I can remember, March 5th very clearly at the SEC stood on a stage launching Scotland's national tourism strategy through to 2030 with the First Minister. It was the day when Boris Johnson had invited everybody to sing happy birthday twice when washing their hands. And of course, we came out of a 2019 performance for the sector that it was incredibly strong. And we're all looking to some very positive years ahead in 2020 and 21 and beyond. And of course, we all know what happened from going from literally hero to zero overnight. So this afternoon's webinar is designed to sort of hopefully give you some opportunity and encouragement that there is opportunity out there to potentially claim monies through insurance companies that might be due to you because of some of the recent changes in case law. I'll leave Roger and Phil to tell you more about that. So and then there'll be the opportunity to have some questions after Roger and Phil have finished presenting. And I'll field those questions once concluded. If you've got any specific questions as well, please use the chat function. The webinar is being recorded as well, so we will be pushing it out to all of you who have attended for revisiting and sharing with other colleagues at a later date too. So on that note, if you're all on mute, which I think you are apart from me, I have great pleasure in inviting Phil, who's got the same hairstyle as me, to take it from here. Thank you, Phil.
Thank you, Mark. Just make sure everybody can hear me. I've been brought to my attention, actually, as is the way that these things tend to happen. I'm actually using someone else's computer. It's actually my wife's computer that I'm using just now. And as I wish actually not only using her computer, but I wish I had her hairstyle as well, as Mark's just picked up on. So without any further ado, I'm actually just trying to go down onto the next screen just now, but I've got a wee bit of a technical issue here. Just bear with me. Seem to have a technical problem here. Mark, I'll go on to the next slide. Just bear with, sorry about this. I'm having a real challenge here, Mark. Page down.
Phil, if you want to take it down at your end, what we'll do, Emma can upload it here, and then we can just march you through the slides.
Okay, sorry about this.
Okay.
I've just a bit of a crash here.
Okay, Emma, you're right to upload it, yeah? Okay, thank you.
Thank you, Emma. Okay, so apologies about that, guys. I've had my computer crashed. I've used someone else's computer, and like all these things happen, there's just been a bit of a disaster that there. So we first met the Scottish Tourism Alliance team, partly because my background had been working in insolvency. I'd spent the vast majority of my career in there. And when we launched this business about 6 months ago, we found ourselves inundated by a number of insolvency practitioners that were bringing us clients, particularly within the hospitality and tourism sector. And as we were going through this, and as we were trying to help the business owners unlock what was unrealised assets that were sitting in there, we decided to change tack actually and start to reach out to some of the trade associations. And the Tourism Alliance has been one of the most forward-thinking ones that we've actually worked with. Because rather than wait until companies are in a critical state and we can't actually help the business owners, we thought we would try and go on the front foot with this and actually try and help businesses prior to getting into that situation. And you just have to look at the numbers, as Mark alluded to, from 2019, just to really understand how devastating COVID has been, particularly for the tourism sector. Industry sources are telling us there's been £11 billion that's sucked out between 2019 and 2020. I mean, it's quite an incredible number for any industry to actually try and recover from. And you can see as his time has gone on, slowly the recovery's been going in. But a big part of that, of what we're trying to fill the gap here, is with that level of business interruption and the way in which the case law has changed and is evolving all the time, how much we can help to try and plug that gap with assets in the form of these insurance contracts that hopefully can try and help businesses to get back on their feet faster. Emma, could you go to the next slide, please? Thank you. There's a book that my son was reading for his exams actually called More Than a Disease, and I actually thought I would incorporate this into the next slide. But a survey that was done in Scotland between November and December 2020, and that was then, I can only imagine how that's evolved. The top line sort of numbers from this has that 58% of businesses were reporting up to losses of 50,000. A further 39% were reporting up to losses exceeding 50,000. And 1 in 10 of these businesses reported losses of more than £500,000. And estimates in terms of job losses are ranging anything from 50 to 80,000. Now, Mark enlightened me that some of this could have been a click on from Brexit, but directly related to COVID in terms of how it's sunk a huge hole in the sector. You know, there's something around about 50,000 jobs that's exited the hospitality and tourism sector since then. If you wouldn't mind getting on to the next slide, please. So what I'm going to do is hand over to Roger. I'll let Roger introduce himself in terms of his experience, and I'll pass you over, Roger.
Hi there, good afternoon, everyone. Hopefully you can hear me and you'll tell me if you can't. My name is Roger Franklin, and I'm the head of the insurance team in a London law firm that's working with SPS on these matters. I thought it'd be helpful just to understand where we are on some of the case law and the potential claims that exist by starting from the beginning and how those cases have developed. I think when the pandemic hit, the first thing that people did was to look to their insurance policies to see what recovery they might be able to make. Now, it is the case that pandemic cover is available, but it's quite rare in the market and it's fantastically expensive. So only a few events like Wimbledon and other large international events had the purchasing capacity to obtain that cover. So what people then did was to look through other additions to their business interruption cover to see what else might be available. And within that, they found extensions like notifiable disease, non-damage denial of access, and actions of a competent authority, which on the face of it gave some hope. So they all started claiming on their policies, and they got a variety of responses from insurers. Well, that's not true. They got almost the universal response was no. So there wasn't much of a variety, but they got a no in different forms. And the FCA down here could see that there was a benefit of intervening in the market just to establish a degree of certainty as to what cover was available. So we had the first test case, which involved about 30 different insurers and 30 different policy wordings and a number of clauses. And the issues that arose on them is that an insurance policy response is triggered by an insured peril, and that has to be the proximate cause of the loss. And the difficulty with a lot of these notifiable disease clauses was that they responded to notifiable disease occurring within a particular geographical vicinity, whether it was 1 mile, 5 miles, 20 miles, whatever. But of course, the insurers say, well, that's all very good and well, but in fact, your losses are caused by the pandemic generally across the UK. not by occurrences within the particular geographical limit of your clause. So that was one answer. The other answer was that the single occurrence or the number of occurrences weren't in fact the cause of the loss because it was the pandemic. So you had these funny arguments about what actually triggers the loss or what triggers the cover, and you had analogies of sort of 12 people pushing a bus over a cliff. Is each one of them the effective clause of the loss, etc., etc. Anyway, that was all dealt with in the first instance, and the general response was that notifiable disease clauses did respond to cover, and therefore people were indemnified for those. But other types of clauses, like what are called non-damage denial of access clauses, which we'll go on to in a minute, didn't. So in order to get a degree of certainty, that was then sent up to the Supreme Court by appeal. And the only issue that the Supreme Court really dealt with was notifiable disease. So there was no appeal on these non-damage denial of access clauses. And what the Supreme Court came to broadly the same decision as the Divisional Court, but by a different route. It said that actually, when you're dealing with something like notifiable disease or a pandemic, what you have is you have to have an effective cause, not the dominant cause. So the reasoning, which is parroted at every debate on these issues, was as follows: said, although an occurrence triggers cover, each and every occurrence makes up the pandemic. So one occurrence of its own is a trigger for cover under these policies. So what that means in the legal test is that rather than be the dominant cause for notifiable disease, it has simply to be the effective clause. And that had quite a significant impact, because when you went back and reviewed a lot of the clauses that lost at first instance, on that new reasoning, you could argue that these non-damage denial of access clauses and actions of a competent authority did respond. And if we go on to the next slide, please, we can see some of the developments of the case law. These are all the cases that the majority of which we've been working on over the last couple of years. And the starting point was really Corbin and King Limited versus AXA. Corbin and King, those who don't know, they own the Wolsey and the Delaunay and a few, the type of restaurants you only go to if someone else is paying. But they're very quite posh places, and had significant losses as a result of the pandemic. And they had a clause which said, it was called a non-damage denial of access clause, and it said, in effect, that if you are closed down by a statutory authority as a result of a danger in the vicinity, then you're entitled to an indemnity. And it was established in that COVID-19 was a danger, and therefore could respond to that type of cover. It was established, unsurprisingly, that the government was a statutory authority, and therefore they recovered under the policy. And that was the first non-damage denial of access clause that responded. And the other issue that cropped up with the Corbin and King case is that when you look at your policy, a lot of the non-damage denial of access clauses and the other ones that we'll go through in a moment, they're quite small inner limits. Some of them can be as small as 50,000, some of them can be up to sort of 100,000 or a million or whatever. But on the face of it, they don't always respond to the scale of the losses. But the other point to note is because these policies and these particular clauses refer to forms of government intervention, that means that the limit applies per lockdown or per form of government intervention. And the other point is that if, depending on the structure of your policy, if you have what's called a composite policy, so you have a number of corporate entities. Sometimes these structures are such that a particular venue is owned by a single corporate entity, and all of the corporate entities are listed on one policy. And that's called a composite policy, and that's what happened with Corbin and King. Each of its restaurant was owned by a different entity. And what that means is that effectively each corporate entity has its own standalone policy, albeit that they're all recorded in one policy schedule. And to give you an example, Corbin and King had about 6 venues, so 6 corporate insureds, they had a policy that covered, I think it was February 2019 to February 2020. So effectively, three of the major lockdowns. And as a consequence, and the inner limit was relatively, I say relatively, I mean, it's quite large sums, but it's 250,000. But because it covered a particular period and it was a composite policy, it meant that each site had effectively three claims because they were three forms of government intervention, and each corporate entity had three claims. So it came to about 6 times 250,000. So what you tend to find is a lot of these policies on non-damage denial of access clauses and things that actually look quite low are written on a composite policy basis, or they're on a per premises basis. And to give you another example, there's a case there we've been working on and just in the process of resolving now, called Oaxaca. That's you might have seen it there in a number of sort of Mexican restaurants dotted around most of the large urban areas. They have what we consider to be per premises cover. So the inner limit for the non-damage denial of access clause is about £1 million, but they've got 15 premises all over the country. So that gives rise to quite a sizable claim. And the same applies to these other ones here. We've got Gatwick Investments, Fuller Smith and Turner. They've got about 36 sites across the country with an inner limit of £1 million. And so what on the face of it can be quite small claims, if you just look at the cover, actually turn out to be a very large form of cover if the policy is read correctly. And those are quite large numbers, but I've also had cases where you do sort of small KFC franchises, and the inner limit was about £10,000-15,000. But one particular company owned about 25 franchises, and the policy period covered 4 of the lockdowns. So you can see in those circumstances that the small inner limits give rise to large claims. So if we go on to the next slide, please. And the reason why I think we're getting interested in these matters now is because of the way the case law has developed. I mean, we're still going through the Court of Appeal on some of these issues now, and we're in 2024. A lot of people made their claims initially and got roundly rejected by their insurers. And obviously, because they've got better things to do, they want to run their business. They haven't been following the development of the case law through this period. So what that means is that claims that might otherwise have been turned down initially are now potentially recoverable. And of course, because we would say that the pandemic effectively struck, if you can put it dramatically, in about 26 March 2020, and that's certainly when the sort of first lockdown was in England. I think it's slightly different dates in Scotland because you were a bit more ahead of us, as always. But that effectively means even though your claim's been turned down, the limitation for these periods is 6 years. So you haven't lost your claim. If your claim was triggered by an event in March 2020, you've got until 2026 to bring that claim. But the clock is ticking, and you need to analyse your policy and see what might be available. So the types of claims and clauses that respond. We have the standard one is sort of disease or notifiable disease cover. They tend to be expressed as cover for notifiable disease occurring within a particular geographical limit. That can be, as I said, 1 mile, 20 miles, or simply vicinity. Now, most of those are all established that they should be covered, provided you don't have what's called a closed list. If you've got a policy that gives a list of diseases and COVID-19 isn't one of them, then you won't be covered. But a lot of the clauses just say a notifiable disease, and COVID-19 became a notifiable disease in or about February 2020. So those generally respond. There's another version of those called sort of hybrid clauses, where they talk about a form of lockdown or an intervening body like a statutory authority or policing authority or something of that nature as a result of a notifiable disease. They generally respond as well. The other ones are non-damage denial of access clauses. Now, these are clauses that were probably introduced as a result of bomb threats and things of that nature. So on the face of it, not written to cover losses caused by a pandemic. But if they simply say that you've had access to your premises denied as a result of a competent authority or government authority, then they respond as well, because obviously the government closed you down. It was a competent authority, and there's been no damage that's given rise to that loss. And finally, we've got the basic actions of a competent authority. They are the ones, a bit like the Corbyn and King one, where it says they respond to damage occurring within the vicinity that gives rise to a closure initiated by a government authority or policing authority, etc. So those are the basic clauses that respond. In terms of the likelihood of them responding, I think all of them should respond, provided you've got the appropriate wording, and that's slightly key, because there's not slightly key, it's very key, because there are a number of varieties of the wording, and it can be quite convoluted. For example, I've mentioned policing authority. If your clause only has policing authority rather than statutory authority or government authority, then the chances are it won't respond, because it will be deemed to be more appropriate for a bomb threat or something of that nature. But in general, there's quite an opportunity to review these policies and to see whether you've got a claim, or large or small. The relevant period, obviously, it has to be the policy year that you want is one that covers March 2020 onwards. I suppose the golden ticket in terms of policy coverage is one that starts in sort of February 2020 and goes on to February 2021. And the reason I say that is because after that, insurers aren't daft. Pretty much everything was excluded for COVID-19 after that. But if your policy incepted in that particular time, then the chances are that you have the relevant clause, and the chances are it's worth looking at to see if you've got an entitlement to make an indemnity. The one final issue I'd make is that it's a lot of people get concerned about furlough and things like that. There's still a debate in the market about whether furlough should be treated as a saving or not, because the way they calculate business interruption losses is, you deduct all the savings from what your anticipated gross profit would have been, and then you calculate your loss. If lots of people received huge amounts of furlough, then arguably that's a saving. But generally, if you were closed down for a particular lengthy period, then inevitably you've suffered an indemnifiable loss of some kind. If we go on to the next slide, please, sorry. What I think is worth looking out for, and what we're looking for, are these 4 types of opportunities. One is missed claims. It may be that you simply didn't have your claim was either, well, I suppose missed claims and claims wrongly denied. First of all, you might have missed the case law and therefore never made a claim under a non-damage denial of access clause because you didn't think that would respond. It didn't have the sort of magic word disease in the clause, so you thought it wasn't worth pursuing. It's worth looking at these non-damage denial of access clauses to see if you have. Other times might be you've had a perfectly good clause which was turned down initially, but the case law has developed since then, so it's worth revisiting the reasons for the initial declinature. It's worth looking at also, even if you've had an indemnity, whether you've had the full amount, because, as I say, if you have something like the Corbyn and King scenario, you might be entitled to multiple claims during the policy period rather than just one particular claim. Again, to give an example, under, I think there's an RSA QIC wording, it refers to notifiable disease and it has an indemnity period of 3 months. Now, a lot of people were quite quickly paid out for their 3 months, but that doesn't mean to say that you don't have an entitlement to a further 3 months later on in that same year. Because if you had 3 fires in the same policy year, you would still have 3 claims, So if you've had 3 lockdowns, then by the same logic, you have an entitlement to 3 claims in those circumstances. And finally, and this is probably a bit more speculative, the Financial Ombudsman Service has been quite protective of people in the hospitality sector, and has given, there is an FOS decision against QBE, where they awarded quite a significant sum of interest on the late payment of damages, which they said should have been paid about 3 months after March 2020, and they awarded 8% or something of that nature. So there may be an entitlement to go back to your insurers, even in circumstances where you have been paid, to say, hang on, you were very late in paying me, and I'm entitled to damages for late payment of damages under particular provision of the Insurance Act 2015. So there's a lot of opportunities out there. It does require going back to your insurance policies, never the most interesting subject for most, so I appreciate that. But it is a real opportunity if you've got the time and the inclination to go through it. And certainly we are here to help if we can. Back to you, Phil, sorry.
Thanks, Roger. If you don't mind going to the next slide. I was hoping, Roger, that you'd have a point here about business interruption to the manufacturer of this laptop that I'm working on, because I thought I was going to put a claim in for it not working quite well.
I think user error doesn't usually respond.
That's what you say. So just to give the panel and the people on the presentation a bit more background on us, we're effectively a private equity firm. We're an expert team of seasoned financial services, insurance, and industry specialists that have built quite a considerable reputation as we're growing it across various different sort of sectors. And the reason why a number of businesses have been working with us and using us is the expertise in getting favourable court rulings. Roger's ran through some of that. We're really quick at looking at policy interpretation, coming back to businesses quite quickly and saying yes, no, maybe, and giving the business owners the option as to what they want to do, navigating some of those causation issues. Again, Roger's touched on some of that stuff as well. Challenging claim denials. We're not afraid to, challenge some of the initial and early setbacks that businesses have had. In fact, we've got a number of cases just now where a number of bar owners and restaurant owners were initially rejected, and as that law has changed, we've been able to go back, review it, and start to go again down that litigation route. And also, from a commercial perspective, is just trying to maximise as much recoveries from our clients as we possibly can. If you don't mind just going to the next slide, please. We try to make what's quite a complicated process quite simple. We take your insurance policies, we review them, we gather those documents, analyse them. Assuming that you've got the appropriate cover, we've then got to go down a claims calculation, looking obviously at the forensics upon the accountancy side of the businesses, pre and just post-COVID. Involved in that is obviously the legal review, communication and negotiation with the insurance business, and then assuming that our clients want to go forward, it's a straightforward litigation preparation and process after that. Next slide, please. What we need to proceed, Roger's touched on it, just a review of your insurance policy, your schedule, and any additional wordings, and then we'll come back and tell you where you stand in terms of reviewing this. Phase 2 of that, if we can go forward, is actually then looking at the quantum amount involved on what that loss is. So there's quite a considerable loss assessment, loss adjustment piece in there before we can present it to the insurance businesses. So we'll need management account, VAT returns, and any business plans that you would have had at that point in time. Next slide, please. Why people work with us is the expertise and experience we bring, the efficient handling, access to resources that we've got, helping with any expert witness accounts that are typically involved in some of these early cases. Cost control, we've got quite a really exciting business model that we work with to try and help SME businesses maximise this, and also the risk management involved in that cost control as well. It's not a trivial task in running one of these cases. And I think that's probably the second last slide, please. So really back to you, Mark, if there's any questions that any of the people want to ask.
Yeah,
thank you.
Phil, Roger, thanks very much for taking us through that. Fascinating. Obviously, I've seen the slides, but obviously, clearly, when you set out the multiplier effect, Roger, of the size of the prize, and dare I say prize, possibly not the right word, but the opportunity that exists, which has maybe been shut. Been a shut door prior is significant, whether you are the smaller KFC or the large £1 million properties with assurance policies attached. Obviously, we've got a variety of colleagues on the call here, and I'm sure some of them will have some questions. I'm just looking at in the chat here at a note from Kenneth Hutton, who is basically saying he would have had cover through a policy they had, which ended in November 19, but their brokers advised them to change companies due to price, and we assumed that we were moving to a like-for-like policy, but it turned out our new policy was clear that we would not have cover. I'm assuming, rightly or wrongly so, and you can correct me, that they might say that's your problem, but I don't know whether there's any recourse to go back to brokers' advice on that front and challenge it. But I guess that's probably what you're asking subtly, Kenneth.
It very much depends on the circumstances. Brokers claims against brokers in relation to COVID matters are quite difficult because they imply such a huge degree of hindsight. Now, if your instructions to your broker were, I want exactly what I had before, so the cover's got to match exactly what I had before, just for a slightly different price, and it didn't, then, and that wasn't drawn to your attention, that might be something worth investigating. But a lot of people change insurance providers quite regularly, and the question to be asked would be whether, as at that time when you changed, given it's taken three or 4 years and millions of pounds to establish some of these cases, whether in 2019 you would have really been influenced by a non-damage denial of access clause or a notifiable disease clause is quite difficult to argue. You're probably more likely to be influenced by the material damage cover and the general BI cover rather than something buried away in page 30 on the BI cover. But if you had a particular concern and that was flagged to the broker, or you had it before and you asked exactly for like cover, then there might be an argument, but generally they're quite difficult because they require so much hindsight.
Okay, thank you. Elaine has asked, is there a minimum claim that you would consider which would be worth your while and the business owners worthwhile?
That's really more a matter for Phil, I think.
No, in answer to that, no, there's not, Mark. We're happy to look at, we know we're working with a whole broad range of different businesses, from large businesses to medium to small businesses. No, there's not.
Great.
I should say as well, in some respects, the smaller claims might be easier insofar as if there's already a decent precedent for cover, then the insurers might not be inclined to debate it so much if your losses obviously blast through the limit of indemnity.
Okay. If anyone else has got any other questions, please do use the hand signal to raise your hand, and I'll come to you. I can see that. I guess I've got a couple of questions. I mean, what about if a business has been was closed and never reopened as a result? What happens in those circumstances?
You would still have suffered the loss, and provided the loss was as a result of COVID and the closure was a result potentially of the failure to receive an indemnity from your insurers. There's a provision in the Insurance Act, sort of section 13A, and it's essentially damages for late payment of damages. So if you can show that the losses you have suffered are a consequence of not receiving the indemnity within a reasonable time, then you can arguably claim for a much higher level of damages if what you've lost is the business rather than the simple indemnity that you would have obtained. But you would have to establish that your losses were purely as a result of not getting the indemnity and not through some other financial difficulties that occurred prior to the pandemic.
And I guess on the reverse of that, we saw when the sector did reopen itself, there was certain parts of the industry had a very strong bounce back, and business was very. Is there still right of claim for the closure period?
We've been looking at a fine example of that is car sales. A lot of forecourts were closed throughout the pandemic, and arguably they were all deferred sales, because as soon as everyone got back on track, they went out and bought their cars. But because the loss is calculated by reference to quite short indemnity period, doesn't necessarily mean that just because you made a reasonable sum later on that you can't recover for the losses you suffered during the period of closure.
Okay. There's a question here from Alistair Sampson. In a policy based on disease occurring at or within a radius of the premises, what evidence do you use to establish that?
For where it's within, there was they call it the FCA calculator, and it was quite a helpful. It is quite a helpful device. So unfortunately, they're thinking about taking it down now. But it was based on all the Imperial College data and all the data that was issued at the time. And what it means is it's reliable up to 1 mile, I believe, or 1 kilometre, but I think it's 1 mile. But you can put in your postcode and a particular time, and it will tell you how many occurrences of COVID-19 were registered within the data during that particular period. And the FCA has issued an edict to insurers that should be treated as good evidence of occurrences with COVID-19. There's been some recent developments in the case law in that the Excel Centre down here succeeded in a case where they had an at the premises clause, and the judge in that case said, well, if in principle you accept the fact that each occurrence of COVID-19 is a trigger for cover, then it doesn't really matter what the radius is, whether it's 20 miles, 5 miles, 1 mile, or at the premises. All you've got to do is overcome the evidential hurdle of establishing occurrences of COVID-19 within whatever the radius is. So, for example, at the premises, if you as an employer or you as a business owner can produce evidence, and it might simply be via a witness statement or employment record saying, Joe Ploggs came in and couldn't come in because he had COVID during that period, then that of itself is evidence of a disease at the premises. But it could be customers. If customers, there was that track and trace system, and the more diligent ones who diagnosed with COVID contacted some of the places they'd been in and said, unfortunately, I've just been diagnosed with COVID and I was in your premises 2 days ago. So those are the types of records that assist with at the premises clauses.
I mean, certainly being somebody who was very much sort of 20 hours a day in touch with industry throughout that duration, in between conversations with the government officials and ministers, I was very much aware of every time there were cases of colleagues saying that they've been unable to open because of staff not coming into work as a result of COVID. So I think there was a lot of evidence of that. So
and some of it, sorry to talk over, some of it, for example, one of the Oaxaca restaurants is about 500 meters from Waterloo. So it's inconceivable, and it's the vicinity argument. So vicinity is likely to be 750 meters, a kilometer, or something of that nature. So the idea that that the insurers probably aren't even going to put them to proof very much of occurrences in those circumstances, because you'd have to be boneheaded not to accept that there was occurrences during that particular time.
Sure. I mean, Alistair, who posed the questions, he is obviously a solicitor himself, who dealt with a number of cases for some of our members, and he's saying he used NHS area stats and the proximity of a hotel pub to care homes and general hospitals, and I guess that probably sort of equates similar to your Waterloo example.
Yeah, well, I'm clearly preaching to the choir.
Yeah. Elaine, this is probably for you, Phil. Elaine's asked, what's the sort of charging structure in general terms? Is it a kind of no win, no fee, or ongoing rates, etc.? If you might want to share that with.
Yeah, it's absolutely no win, no fee. So we review the case. If we decide to go ahead, we split any of the winnings 50-50 with the business, straight down the middle. And we pick up all the costs for the litigation, the loss adjustment side. So we carry the heavy burden of the cost on it.
Okay, great. Anyone else got any other questions for now? I've got a couple more here. Obviously, there's a bit of lifting to do at the front end. I mean, how do I obtain evidence of COVID in order to meet the requirements of the policy? I mean, we touched on a bit of that.
Yeah.
But
well, the first thing is the evidential hurdles depend upon what particular clause you have. If you've got a type of clause that talks about 1 mile, then it's not that difficult because you can use the STA calculator and plug in your postcode and the date. If some of them are 20 miles, and it gets even easier, that basically the narrower the radius, the more difficult the evidential hurdle is. But in general, it's not that difficult. And if you're at the premises, which is probably the sort of narrowest one you can get, then it would require a short witness statement from the owners of the business saying when they had COVID at their premises.
okay. And then Leah's just popped in the chat here. There's just checked my response from her insurer at the time. Would this change following recent cases? The key part of the extension to note is that it states cover will be provided in the event of the notifiable human disease manifesting itself at the premises. This means that restrictions closure as a result of government measures in place to restrict the spread of COVID-19 would fall out of the scope of the cover.
She's asking for the secret sauce on day one, you see, but the short point is that yes, that would now respond because there's been the at the premises judgment, which came out about 4 or 5 months ago. Yeah. I suspect her letter was about 3 or 4 years ago.
So worth coming back to that.
Yeah.
Yeah. Okay. Good. And I guess, you know, you've made it clear, I think, on several times. I think anybody, you know, if your claim's already been turned down, should I review matters? And I suppose if there's any doubt in your mind, then obviously, why not?
Yeah, by all means. As I say, there are a lot. I mean, there are obviously some that were correctly repudiated, but there are a lot that turned down that should now respond as a result of the developing case law.
Are there any insurance companies who are ones that you would say are I say squeaky clean? I use that lightly in terms of they are very robust and there is no real reason to challenge or there's no chance. So, and are there those who are perhaps a little loose at the edges that would definitely be worth questioning?
I did it because all insurers have a variety of policy wordings. So we tend to go by the particular policy wording rather than the insurer. But there are, you know, RSA and QIC targeted the hospitality sector through a cover holder called Eaton Gate. They're generally responsive. The Hiscox ones have generally responded. The Liberty Mutual ones have generally, but I wouldn't. The fact that I don't name the insurer doesn't mean to say that it's not worth checking, because a lot of insurers operate through cover holders, and you know, sometimes you don't even know who the insurer is behind the cover holder unless you read the fine print. So it's more policy wordings and clauses rather than particular insurers.
And you've referenced, we've spoken a lot about, you know, hospitality organizations in particular, or accommodation providers. There are obviously a number of businesses and operators on the call here who are in the travel trade, tour operators who were obviously experiencing disruption of their business because of closures of premises. So I take it their claims potentially are still very worth looking at.
I think there are certain sectors that will struggle. For example, the financial services sector. You know, law firms could carry for some absurd reason. Well, actually, perfectly obvious. We're all lovely, but lawyers were referred to as key workers. So we didn't have any trouble working, and all of our officers could immediately decamp to home and carry on trading. So there was no real loss. So financial services ones create a difficulty. If nevertheless you've got a notifiable disease clause, that's not dependent upon you having premises that were closed. It's just dependent upon you suffering a loss. So if you've got a notifiable disease clause that provides for, you know, an occurrence of a notifiable disease within the particular vicinity giving rise to a loss, then even if your losses were dependent on third parties not being able to trade, you still have potentially a claim. The non-damage denial of access clauses and the sort of actions of the competent authority clauses, they tend to be clauses that only respond in circumstances where your trading premises were closed as a result of government intervention. So that's why the hospitality sector is an obvious one, insofar as nearly everyone within the hospitality sector and some other things like tattoo parlors and gyms and things like that were all required to close, and therefore it's premises-based cover. And if you couldn't operate from your premises, then you've suffered a loss.
Soft play centres, I seem to remember being told. Yeah. Obviously, as we have come out of COVID, I mean, this for some businesses, it's obviously taken time to rebuild their revenue stream, particularly where there was disruption to international travellers. And obviously that I talk about the golf sector. Many of those pre-booked golf tours were postponed, if not through to 2021, but are beyond into 22. Is there again a sort of claim back, even though it's fell without the year of 2020, beyond that, because measuring it, I guess, is a challenge as well?
I think there's certainly a claim if the reality is that events were cancelled as a result of COVID, but those are the types of ones that you'd have to have a notifiable disease cover or some kind of events or exhibition cover that responded, rather than the premises-based cover that is generally available under non-damage denial of access clauses.
Okay. Is there any more questions for now? I see, Alistair, you've asked the question. I'll pass that on to Phil. Anyone else? I mean, clearly, you know, again, if it goes to that saying, we all know that there are still some real challenges out there for businesses, and we're very aware of some businesses who have had to close their doors, and had they perhaps been successful in their claim with a payout at the first time, they would still be with us. So many won't know about these developments and the opportunity to challenge more, so I'll go back in again. So I do think it's important to share this with colleagues. Elaine, we will make sure that everybody from today has the contact details, importantly for Phil and Roger as well, through SPS. So if you do want to follow up with them, the invitation is there to do so. And obviously, I know you know, these guys are very keen to work with you and support you, and that's exactly why we as STA are keen to partner with any organisation that can help, you know, business thrive, prosper. So it would be good for you to get in touch if you think at the slightest chance there may be something going back for, but also telling any colleagues of yours who have not been able to join the call today. The presentations and the recordings will be made available to all of our members after the call, and we've passed on your contact details if you wish, in terms of your email addresses to the guys, so they have the opportunity to follow up with you, and unless we have any of you tell us you would rather not be passed on, please do let us know. But we're working on the assumption that you were happy for us to do that. Is there? I'm coming up to 2:25, and unless there's anything else, I'd like to just, on behalf of the Scottish Tourism Alliance and those who are on the call, to say thanks very much to both of you for joining us today. And obviously, we will stay very much in touch and continue to share and make others aware of what you're there to do in terms of offer of help, and appreciate that. But if you've if you've got no other questions, I would like to say thanks all very much. Enjoy the rest of your afternoon. Please do stay in touch with the STA. There's plenty going on in our industry, as you know, and obviously with changes in government recently, government ministers and things, we're of course very keen to continue to inform those in office as to just how the state of the nation is. But hopefully for the majority, we will see the continuous bounce back, the full year performance of up until the end of 23. The results will be published in a couple of weeks' time. But one thing I do know for sure is that the international demand is there. The frustrations are those that the industry can't service it all because there is some shortage of supply in accommodation, but of course, as well as loss of workforce as well. So we'll get the communications, as I say, out to you. But please do feedback anything else that you have to us after the webinar. If you've got any other questions, we can put you hopefully in touch with the right people. But thanks all for joining, and thank you again, Phil and Roger.
Thank you.
Thanks,
everybody.
bye-bye.
Thanks everyone for your time.
Bye. Thank you.
Bye-bye.
Bye-bye.
Bye-bye.